Thank you.
Mr. Wilton?
Your Honor, may it please the Court, my name is Timothy Wilton. I represent the plaintiffs, appellants in this case, who are big dig workers, who are, first off, the first proposition is that on the last case that this Court just heard, that the Court upholds the Industrial Accident Reviewing Board. Should that be the case, then the question becomes, how do all those big dig workers who all those years were not receiving those benefits they were entitled to, how do they get that money? And the workers' compensation system provides absolutely no vehicle for that to be done. However, there is a vehicle, and that is a class action in Superior Court under Chapter 93A, which is essentially...
Excuse me, I misunderstood. There is absolutely no way for your clients to get the money that was due them if we were to decide the prior case the way the worker asked us to decide it?
That's correct.
There's no way.
Yes, that's correct, Your Honor.
There's no way for them to...
Not the workers' compensation system.
Well, there's no way because they didn't avail themselves of the rights under the statute to proceed with their claims.
Most of them, Your Honors, as is typical in consumer protection class actions, most of them didn't even know they were being wronged. Most of them, the vast majority of workers' compensation claimants simply receive their benefits without getting a lawyer. They get their benefits, they receive them for a while, they go back to work, and they don't realize that they have been deprived of somewhere in the neighborhood of 20-25% of their benefits.
So there's no action outside of a 93A action, I'm not talking about workers' comp, but no action of contract or anything else that can be brought to get this money? Third-party beneficiary of these contracts, anything like that? Because 93A, conjures up a nuclear weapon kind of situation.
I think
in a situation where it appears if they're owed the money, they ought to be able to get it. And I'm sure the insurance companies, if they lose, would say, yeah, okay, we're supposed to pay them the money, with interest, I assume.
Well, Your Honor, of course, counsel for the insurance company will be up here in a minute, but I certainly expect that.
But am I wrong, haven't they, in this case, paid the fringe benefits at issue pending the resolution of McCarty?
To the first,
so they have
to my three individual clients, yes, Your Honor.
So you're not losing the use of the money, which is one of your arguments.
These three individuals are not.
Right.
But, Your Honor, there are very few people who have actually hired lawyers and litigated
Mr.
this
Wilson,
as
I understand that, but it is an extraordinary position. Let me say I don't understand that. I will accept that proposition, but given this very highly regulated area, which said, in exchange for giving injured employees certain protections, you give up certain rights. There are endless cases filed by injured employees who don't think that they are getting what they should be entitled to. There may be many, I don't know, injured employees who don't challenge what they're getting. But it would seem to me to be quite extraordinary for a court to conclude that if somebody doesn't exercise the rights that the legislature has given that person, in other words, waives them, even if you waive them in ignorance, or waive them because it's not worth it, or waive it because you're getting by on what you're receiving, or waiving it for any number of reasons, to say some years later, when you find out that your best friend, in fact, was getting paid more, because your best friend or your colleague, in fact, challenged what he or she was receiving, you can now go back in under a 93A action. Isn't that what you're asking us to say?
I'm not sure that's exactly what I'm asking you to say, but first, Your Honor, I would like to take you back just a little bit in that proposition, and that is when you speak of waiver without knowledge. I don't believe that there really is such a thing.
It's not waiver without knowledge. Well, it's saying that it's the functional equivalent to me saying there's a statute of limitations.
There is. I have no challenge that when the defendants raise it.
We've got a whole carefully worked out. It's not as if these workers never had an avenue never had an avenue to challenge what they were receiving.
Your Honor, I represent, or I purport to represent, because the class motion has not been acted upon, but nevertheless, I claim to represent, and my complaint was dismissed, so taking it as true, I claim to represent a class of people who are injured workers who accepted what the insurance company told them, and the insurance company misled them, and it paid them the wrong benefits.
But that would mean that any time we decide that the company has been doing X for X number of years, and then somebody raises a claim. I mean, our books are filled with those. Some individual raises a claim and prevails. No question that there have been other workers who haven't prevailed because they didn't challenge it. And your argument now is, notwithstanding the statute of limitations, notwithstanding anything else, you can ask to certify and to find those people who didn't receive whatever it was that this worker is now claiming and bring them all back in for a 93A action.
No, Your Honor. I do not claim to be above the statute of limitations.
Which is what, a 4-year statute?
For Chapter 93A actions.
Leave aside the 4-year statute of limitations. And
Yes, sir.
what then is, I mean, again, it's anybody can challenge.
I believe the answer, Your Honor, really is that your hypothetical or your proposal looks at it really backwards. I think that you need to go back and look at what these insurance companies were faced with at the point in time that they were told specifically that they were paying the wages, they were paying the benefits at the wrong amount.
No, but how can you say the insurance companies misled? There's never been an appellate decision on the issue. So how, just because there's been maybe one decision by the Industrial Accident Board, how can you say the insurers have misled
Your Honor,
the workers?
there have been hundreds of decisions by by administrative judges enforcing that. The decisions prior to the 1991 amendment were exactly this. It said if you're on a public works project, your fringe benefits are
But
included.
91,
And
the
that's
whole
before the
statute was
91 amendment.
changed. The statute was changed in 91, so so the ballgame changes, and there hasn't been an appellate decision, and this case has been pending for years. The McCarty case was
There was
pending
another
for years.
Industrial Accident Board decision shortly after that 1991.
Okay, but there weren't
It said the
hundreds.
same
There was
thing.
maybe one or two industrial accidents. But so how can you say the insurance company knew that what they were doing was wrong for purposes of 93A? It wasn't clear.
All right. And to the degree they did not act in bad faith, then they're not liable for multiple damages. To the degree they made a knowing decision to violate the law, they would be. But if it was not knowing, they are still liable, and here's how. They're liable under 93A because they have refused to heed a statute which is designed for the protection of consumers.
But if we adopt your position, I mean, the legislative intent, it seems to me, in the workers' comp field was to take the Superior Court out of this complicated field where there are many, many, many cases and have it all regulated and adjudicated by an administrative agency.
And I disagree with that, Your Honor.
That looks like it was the intent. I mean, they took this, well, you agree there's no jurisdiction right now in the Superior Court to hear these claims.
There is jurisdiction to hear Civil Rights Act claims, to hear employment.
Okay, I said to hear these.
Any statutory
okay,
claim.
but to hear the claims, that the workers' comp ordinary claims don't go to the Superior Court.
And that's not what this says, Your Honor.
But having taken them out, having taken the Superior Court out of the area of industrial accident disputes, the Superior Court would have to go back in for purposes of Chapter 93A because they would have to decide all these underlying
No, they would
issues.
only have to decide significant issues of law. The underlying factual questions have already been determined in the workers' compensation system. The factual question of whether this worker was injured on a job, on a public works project, all of the factual questions are there. The only question, really, in this case or in any other 93A case like this, is whether or not the insurance company has properly interpreted the statute in this case, and if they have not, they have refused to heed a statute providing benefits to consumers, and they now have to give those benefits to the consumers, and that through this class action device. If they did this intentionally, maliciously, or anything like that, multiple damages are available.
But
even if
doesn't
they
the
did it-
Division of Industrial Accidents have statutory authority to investigate questionable claims practices
Yes,
by the
they do.
insurers?
Yes, they do,
And so
Your Honor.
doesn't that also indicate legislative intent that that's where it's to be, and they can provide by regulation guidelines as to what constitutes a questionable claims practice?
Your Honor, I spoke to a workers' compensation lawyer yesterday about that, and I was told that's toothless and useless, that, in fact, to his knowledge, no one has ever used that procedure. Perhaps they have, but to his knowledge, no. But, and I know this is beyond the record, and I don't want to get beyond the record, but
Mr. Wilson,
but the point is that there is no enforcement mechanism other than reporting to the insurance commissioner. There's
Mr.
no.
Wilson, let me ask you this.
Yes.
Regardless of whether or not we agree with your position, looking at your case and what the judge did in this case, there was no decision from either the appeals court or from this court on this particular issue, on Mr. McCarty's particular issue, correct?
That's correct.
How on earth can you have your case proceed? I mean, you started off by saying, assuming we rule in favor of Mr. McCarty and his colleagues in the first case. How on earth could this case have been going forward in the Superior Court when there wasn't any ruling? In other words, why should we even reach your case at the moment? I have to issue a decision. What am I supposed to do? Stay my decision until we've decided McCarty?
No, Your Honor, although I don't.
I mean, that would be extraordinary, wouldn't it? Because
Your Honor,
if that were the case, let's assume that that were the case, one could, for example, say, if we rule in favor of Mr. McCarty, your case has been legitimately dismissed, as it should have been, because there was no ruling to that effect. You then file a lawsuit, and a Superior Court judge says, look, I don't even have to decide whether or not you're entitled to a 93A action, because the law wasn't settled. So even if you are entitled to a 93 action, there's certainly no wrongdoing, unfair or deceptive trade practice here. Right?
Well, Your Honor, first off, I think that the Attorney General agrees with me, and there's a regulation to the effect that it is an unfair trade practice to refuse to heed a statute which is designed to protect
yes, but
consumers.
the insurance companies are not refusing to. In other words, what you're essentially doing is to say, I'm waiting for an advisory opinion from the Supreme Judicial Court, but meanwhile, I want my lawsuit to proceed. We have time standards. You're going to certify the class. You're going to litigate a case. I don't understand why I even have to decide this case before I decide the McCarty case.
This case, the sooner it was filed, the better. And
why?
Because the statute of limitations is running and the big dig is winding down. And there are many, many of my class members who are perhaps outside the statute of limitations already and have lost that money permanently.
What you're essentially saying, and that was my concern when I asked you before, what you're essentially saying, if at some point, because one particular worker chooses to challenge, as he is or she fully entitled to do under the workers' compensation statute, everybody else can sort of say, well, you go ahead and do that, and when it's settled, and by the way, we'll just file this holding statute over here. Nobody's quite sure what the law is. There's been an amendment to the statute. We can't rely on if the law was so clear prior to 1991, what am I to make of an amendment?
The amendment, Your Honor, I believe simply codified what the reviewing board had been doing up to that point.
That's one argument. Another argument is to say, no, it didn't. I mean, the legislature doesn't always take it upon itself to codify something. It may say, we don't like what's happening here. We're amending others. I don't know the answer.
I understand, Your Honor. And similar to the counsel in the last case, I don't see ambiguity in the language. Frankly, I think that it's pretty plain that there's an exception which refers to the fact that public works project employees have fringe benefits included in their wage rates, and that exception can mean nothing else, it seems to me, than that it should also be included in the average weekly wage, because that's the statute that's saying except as that statute says.
And one highly informed administrative law judge who does this all the time said, it's not that plain.
Your Honor, one out of hundreds.
If your case, in fact,
Your Honor, I'm sorry. The reviewing board, it went up to the reviewing board, they reversed. Prior to it going to the reviewing board, I don't know. I would be speculating to say what any other administrative judge did, but every single other administrative judge has ruled the same way as the reviewing board did, and the way the reviewing board did prior to the 91 amendment, and the way the reviewing board did after the 91 amendment. I mean, the reviewing board's been totally consistent in this regard.
The reviewing board has, but what I'm saying, it's not as if they are frivolous arguments on the other side.
And, Your Honor, a frivolous argument is, as this Court has said, a frivolous argument opens up the defendant to multiple damages. But a single damage violation under Chapter 93A is made out when the defendant does not follow a statute that's supposed to give the public benefits. He's saying, I'm not going to give the public those benefits. And even if they're doing it because they have a good faith basis for challenging, and 10 years later they're determined to be wrong, during that 10 years the public is not getting the benefits that those people are supposed to be paying them. And that's a wrong that they've committed.
And the mechanism is to challenge that under the Workers' Compensation Act.
But highly inefficient, Your Honor, and simply, frankly, unrealistic in the real world, because most of these people have absolutely no idea about these statutes.
I'd like to ask a question. Can you tell me how many people we're talking about if this class was certified?
I can only speculate, Your Honor. There's been no discovery in that regard. I would speculate that it's a substantial number, and I can't say whether it would be hundreds or thousands.
All of your clients had their fringe benefits paid?
My three did,
And
yes.
is there any reason to believe that they were singled out and that nobody else's fringe benefits were paid?
They obtained their fringe benefits because they hired a good lawyer who fought for them. It took him several years and several court appearances in order to get those, all the while being opposed by the defendants. And yes, eventually they got them. But again, the classic 93A176D case is made out when the insurance company refuses to pay the benefits and forces you into litigation in order to obtain them. That's a classic 93A176D, as this case is, I believe.
if your case, in fact, had gone to trial as a class action and you prevailed, and then it came up on appeal, and while it was up on appeal, the companion case that was argued today were decided in favor of the insurance company, what would happen to your case on appeal?
I believe, Your Honor, that I believe that if this court decides in favor of the insurance company
No, that's not
on
the
their...
question that Justice Spina asked.
Pardon me?
It's not the question that
Oh, I'm
Justice
sorry,
Spina
I
asked.
apologize.
I'm saying, if your case, if you had succeeded,
Right.
Gone to verdict and won a verdict in your class action case,
Mm-hmm.
And
the
started to
insurance-
collect it.
and the insurance company appealed, and while that appeal was pending, the companion case, McCarty versus Wilkinson, came up on appeal and was decided in favor of the insurance company. What should happen to your appeal?
I believe that, first off, my appeal probably would have been paired with McCarty for argument as it is here, but had it not been...
Mr. Wilson, they might have been years apart.
If McCarty's appeal is decided before my appeal, presumably depends on whether the insurance company has saved the issue that's the substantive issue, which I imagine they would, in which case this court would reverse my case, no doubt.
And would your clients be prepared to give the money back?
Your Honor, to the extent that the money has been paid, I doubt that anybody's
Mr.
going to pay out
Wilson,
any
but-
money before the case is ultimately resolved on appeal. It's not the usual thing.
Thank you, Mr. Wilson.
Thank you, Your Honor.
Mr. McDonough?
Thank you, Madam Chief Justice. And for the record, I am Miles McDonough. In this case, I represent the Appalachian National Union and AIG Claim Services. Your Honors, let me respond to Mr. Wilson's remark to the effect...
Can I ask you first off, and maybe you're intending to get to this, is there any mechanism under the compensation statute where his claim could be adjudicated?
Yes. The short answer is yes, Your
Where
Honor.
is it?
In 1991, Chapter 23E, I believe Section B8 was enacted, and regulations were promulgated. I believe the site is 452 CMR, Section 105, Sub 3.
This in your brief?
I believe it is, yes.
Okay.
And that those provisions were specifically enacted and promulgated for unfair claims practices acts complaints in the workers' comp context. So I think that it doesn't get any clearer under this Court's guidance in cases like the Cabot case under the Security Statute 110A and the Ryder case under the
The automobile
93B.
franchise. So what you're saying is that these people, these workers and their lawyers or lawyer, could have brought a proceeding before the board or before the DIA invoking those provisions and asking for whatever relief is appropriate.
And Section 7 and 8 would provide penalties under Chapter 152. So you have a in the event that there were any conduct that were deemed, penalty appropriate, if you will. So that Mr. Wilton.
I would assume this might come up in other contexts practically every day where some worker goes to a lawyer and the lawyer says, oh my gosh, they paid you the wrong benefits for whatever reason. We got to go back to the board and get you what they should have paid you.
Sure.
Well, when you cite 23EB8, B81, that's what I was asking about before.
Yes,
that the Division of Industrial Accidents has the statutory authority to investigate questionable claims practices by insurers and employers and to provide by regulation guidelines as to what constitutes a questionable claims practice. And I asked him that question, but he says that has no teeth and it's.
Well,
it's there.
You're making it sound as if he's talking about, well, you can request an investigation, which is one thing. You're making it sound as if counsel for someone affected by this can actually file a claim, which is two different things.
They are, but they could be related, Your Honor. If there's an administrative claims process.
Can you file a claim? Can a lawyer on behalf of a worker file an actual claim and get it adjudicated in front of the board, claiming that there's been a unfair or deceitful whatever, or even the money hasn't been paid that should have been paid and all that kind of stuff?
There are penalty provisions in the statute, and I
take it that what the legislature in part was trying to do is to say there's a normal appeals route. It's a normal appeals route. If you think there's a pattern or practice, before you get to file a claim on a pattern or practice, because that's just another way of doing another appeal, have some determination that says, in fact, there appears to be some kind of pattern or practice here. I assume that that's what that provision provides for. I mean, that's as I read it.
They laid it out, and they even promulgated regulations for that process.
And the purpose of that, I assume, is because the DIA is familiar with these types of claims, and it would be much easier for it to discern an unfair practice than for the Superior Court, which doesn't have any familiarity with these cases. And this is also for the legislative intent that this was all to be kept out of the Superior Court.
And in 1912, that's exactly what the Commission said, Your Honor.
If we hand down a decision in this case, assuming that you lose McCarty, that says, okay, it's obvious the legislature wanted to preempt this area, much as it's, securities and Ryder Oldsmobile. And there is a remedy, and counsel, who represents these folks, may file a claim directly with the board and have it adjudicated. That's okay with you?
File a claim?
A claim on behalf of all these folks that they got gypped.
A class action before under Chapter 152, Your Honor? Or a claim in the Superior
No,
Court?
there's no mechanism for this action at this point in time to be filed before the Workers' Compensation Board, is there?
No, I believe that's correct, Your Honor.
Yeah, there's no way this claim can be pursued before the Workers' Compensation
Then
Board.
why are you telling?
The claimants have had their remedy under Chapter 152.
Right. If they disagreed with the amount that they were paid, they could have challenged it within the Workers' Compensation system, just as Mr. McCarty did.
And they could have challenged even the methodology under which that amount was arrived at.
That's
Correct.
my point.
So
the legislature seems to me, first of all, this may not be a consumer protection statute, and it's a statute that employers have to pay because the legislature decided about 100 years ago that it was far too costly to individual workers to have to sue every single time. And for 100 years, The legislature has tried to make it as fair as possible, but to keep it self-contained. That's what I was trying to say to Professor Wilton.
Yes, Your Honor.
So when they changed it, they said, it may be that you've got a persistent practice, keep it within the workers' compensation statute. I think it's probably very dangerous for an insurer to get an adverse ruling as to whether or not there's a persistent practice from the Industrial Accident Board. But had somebody commenced the proceedings in reliance on all of the, I don't know whether it's in the record, but Mr. Wilton represented hundreds of decisions of industrial accident judges that would have found in favor of his non-identified clients.
May I respond to that, Your Honor? First of all, there are many decisions going the other way. There are informal decisions where people come in and make initial rulings. And
I understand. I took it as all outside the record anyway. Nobody's come in with a I've got in this case a decision of an industrial accident judge.
My point, Your Honor, would be that it's no accident that people aren't seeking penalties with regard to the issues that are being litigated in McCarty. They know that this is certainly a very meritorious position. That's the reality as to what's going on. There's no truthful. And by the way, heaven help us if this court should ever enter a ruling that Chapter 93A provides a remedy because, as Mr. Wilton conceded, his clients were supposedly unaware of rights that they had out there. There is no way the legislature ever intended.
No, and I think that would absolutely turn the workers' compensation statute on its head.
And so the world in the Superior Court as well, Your Honor. Let me touch upon a few more points that I'd like to quickly address. The Section 3 exemption provides for exemption from 93A of, I'm quoting the statute now, transactions permitted under laws administered by any regulatory board acting under statutory authority of the Commonwealth. There are some ellipses after the words regulatory board there, Your Honors, but those, I just wanted to hit those markers there. What we have here, Chapter 152 specifically permits insurance comp carriers or employers to raise issues. As a matter of fact, the statute even contemplates there are fees to cut down on costs associated with the department. Specifically permits the bringing of defenses or legal issues, of course. The process is administered by the Department of Industrial Accidents. It is a regulatory board, and it is acting under statutory authority. Your Honor, Justice Greene's MCLE publication, and now edited by Judge Botsford, takes Kelly and Boduk, which were the basis for the trial court's ruling dismissing the case, and characterizes those decisions as perfect examples of exemption cases, which of course they are. If they're not exemption cases, Section 3 means nothing, because if they don't qualify, nothing in the world could qualify for exemption under Section 3 of Chapter 93A. I also want to point out that with regard to the exclusivity concept, Section 12 is very meaningful, along with Section 24, because Section 12 is about as clear an example. It's consistent with the Commissioner's report that Justice Cowan was referring to, is a clear declaration by the legislation that these disputes about benefits amounts are hands-off with respect to the superior courts. It couldn't be any clearer. The appellate avenue on these issues is from the DIA reviewing board right up to the appeals court. And the Nason treatise and the Abergas case, I believe, both state flat-out superior court's jurisdiction with regard to comp claims is limited to enforcement. There was never an enforcement issue here because every time the board ordered something, if they flipped the initial determination in favor of the insurer, which happened on a number of occasions, such as with Mr. McCarty and others, the carrier paid. They paid the freight as they went, but they preserved the issue and said, folks...
Well, they wanted to avoid the big interest penalty. I mean, the big interest. But they paid.
They paid and they preserved the issue so that we could be here today on this, Your Honor. So this has been a whole dynamic going on, which is all the more reason why Chapter 93 is inapposite here. Under the Thaler case, when you have the judge, the trial judge in the trenches charged with administering and interpreting the statute, agreeing with you, and as Justice Cowan referred to, there was no appellate guidance, is not yet any appellate guidance on a very meritorious issue. That is not the stuff of which Chapter 93A is made. And I would commend to the Court, I know the Superior Court decisions, but Judge Billings, himself a commentator on Chapter 93A, has the Malonis case, and Judge Van Gestel, who deals with 93A in the business session all the time. Both of them have opinions. The Savers case of Judge Van Gestel that hold to the effect that when you're in litigation, you've got a judge, you've got a statutory authorized person, monitoring the proceedings, making the calls. That's not a marketplace. That's not a consumer environment. And that's what we have here, a regulated, closely regulated process. We don't have a marketplace. The Amids case, back in 1920-something, I believe, characterizes the workers' comp relationship as sui generis. It was created, that tripartite kind of relationship between comp carrier, employer, and employee was created in large measure to protect the employment relationship.
Well, it was created in large measure to protect injured workers who were being forced to go through Superior Court. They were given an alternative remedy, which was very expensive, very time-consuming. They were given an alternative remedy.
Less risky.
Far less risky, far quicker, and not very onerous to challenge. The employer has to pay almost immediately, and if you think that you're entitled to more, you have a pretty prompt, straightforward, non-complicated proceeding to challenge that.
Yeah, efficient. And Your Honor's...
Well, it may not always be efficient, but there's a quid pro quo. And if you essentially say, well, there's a whole group of people who, if it's later determined that they had some claims which they didn't challenge, they can now go into the Superior Court. That's what I was trying to address with Mr. Wilton.
Yes, Your Honor. And with regard to this Court's jurisprudence more generally on Chapter 93A, I would also submit that this case falls into the rubric of the Van Dyke case, the BSO case, the Clegg case, more recently the Bobbitt case, all of which deal with situations where insurance companies, even putting aside the exclusivity concept, even if this were a Superior Court situation, 93A would not lie anyhow because we have a plausible legal issue. That's what we have here, just at base a garden variety dispute about how to interpret a statute. An unusual one, a novel one, but that's all the more reason why it should not be a 93A situation. The carrier would have to borrow a term from the Lazarus case of this Court, watch both flanks if it did not litigate this issue. Because you can imagine you can imagine what an insured would say if they were to hear that, well, wait a minute, Judge Harris agrees that you're right. Judge Harris says you've got the right analysis here. But now you're laying down on the issue and you're paying higher comp to all these people? I mean, please, and now you're asking us for premiums associated with these higher payments? It's absurd to impose 93A liability there. I want to touch very brief, and on causation, there's no causation here. The employees admit in their brief they got, quote, got everything, unquote, they were entitled to under Chapter 152, so there's no causation anyhow.
Well, there's no causation for these three particular people.
That's right, Your Honor. I'm just saying the record is clear in the complaint and in the record on that. I do want to take just a moment, Your Honor, to talk about the anti-SLAPP statute. I know it's the last argument raised in the brief, but the Duracraft case and the Lopez case, I believe, do indicate that the protection of the statute is very broad. We have here the purest form of petitioning. Somebody being brought into a process that they don't go into, they get brought into under Chapter 152. Somebody claims to get injured, you got to show up, you got to litigate the thing, and they're asserting their legal position on a novel issue of statutory law. It doesn't get any clearer than that as insofar as conduct protected under Article 11 is concerned. That's what they've done here. It would be an abuse of Chapter 93A, and as a matter of statutory interpretation, Chapter 93A must, like all statutes, bow to the Constitution. It would be an abuse to allow 93A to be applied to chill any insurer, comp or otherwise, from litigating issues. This is an abuse of Chapter 93A here, Your Honors, for that reason. If I may just wrap up, Your Honors, we ask that the Court affirm the judgment of dismissal based either on the exclusivity principles under Section 12 and Section 24 or on any of the alternative grounds that we've argued. Thank you very much.